Is a defendant released after a mistrial? When a judge stops a trial midstream and declares a mistrial, emotions run high in the courtroom and at home. Everything is suddenly on hold, yet nothing has been decided. Understanding what that pause really means, and what comes next, matters for anyone whose freedom is on the line. From a legal standpoint, a mistrial wipes the slate of the interrupted proceeding, but it does not wipe out the charges. Double jeopardy protection does not attach because there has been no final verdict, so prosecutors may start again with a new jury. The court immediately reassesses bail, flight risk, and public safety concerns. It may keep previous bond terms, raise them, or even deny release until a new date is set. Whether the defendant walks out the door after the declaration depends on a cluster of factors. Judges look at the seriousness of the alleged offense, any prior failures to appear, community ties, and conduct shown during the first trial. In lower-level matters, a judge may allow temporary freedom, sometimes with electronic monitoring, periodic check-ins, or strict travel limits, while a homicide or violent felony mistrial often keeps a person in custody. An experienced lawyer can argue that continuing detention is unnecessary, pointing to cooperative behavior, employment, and strong Long Island roots. When prosecutors insist release would endanger witnesses or undermine confidence in the process, your lawyer counters with concrete safeguards and proposes a bail amount the family can meet. Suffolk County criminal defense attorney Jason Bassett emphasizes that a mistrial can open the door to new negotiations. If the original evidence appeared shaky or jurors leaned toward acquittal, the attorney may be able to secure a favorable plea offer, or even a dismissal, before any new jury is sworn. Behind every mistrial lies procedure. The moment the jury deadlocks, a key witness falls ill, or misconduct taints deliberations, the judge declares the trial invalid. The case is then placed back on the calendar. Both sides review transcripts, shore up weak spots, and decide whether a fresh trial is worth the time and resources. Defendants retain the presumption of innocence and all constitutional protections during this interim phase. Temporary release conditions can be exacting. Courts may order electronic bracelets, require weekly reporting to pre-trial services, forbid contact with alleged victims, and confine travel to Suffolk County. Violation of any term sends the defendant straight back to jail while the new trial is scheduled. There are also clear exceptions. If the charges involve violence, weapons, or a demonstrated pattern of witness intimidation, or if the individual's criminal record shows repeated flight, the judge can keep the person behind bars. Public safety and the integrity of the justice system remain paramount. The law firm of criminal attorney Jason Bassett understands how disruptive this limbo can be for families. Its team works quickly to gather fresh evidence, line up witnesses, and press for the most favorable bail outcome while preparing a robust defense for any retrial. Should the prosecution decide the case no longer merits another run, the law firm stands ready to push for final dismissal and closure. If a mistrial has upended your life, reach out to criminal attorney Jason Bassett at 631-259-6060 or visit 320 Carleton Avenue No. 4200, Central Islip, New York, 11722, United States to take the next step toward protecting your future.